Is there something wrong with this? I think it's planning. I don't know. Does it say? Just say you're on, right?
Well, yeah, obviously. You should speak with the attorney before you go on. Everything will get.
Okay. Are any of these people in the waiting for a reason?
It came out.
Got it. Who's representing Miss Blackman?
I am, Your Honor.
Do you need to speak with her?
No, I have.
Okay, we're on the record in the matter of the people of the city of Lansing versus Adrikia Blackman. Filing number is 22L2709711. Council appearance.
Matt Staples on behalf of the city of Lansing.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Adrika Blackman, who is appearing separately from the Union County Jail.
Today was the date and time set for a pretrial on failure to display valid license. Let's see, how are we proceeding on this?
Your Honor, at this time, Ms. Blackman, well, the report is that she had her license is suspended. We will be requesting 30 days for her to make efforts to clear those suspensions and have a valid license for an offer from the city.
We can do January 10th at 9:30. Well, we reset this for January 10th at 9:30. Any additional matters for the record?
Nothing for the city.
Your Honor, nothing from the state except for I didn't know if there, it's my understanding that there could have been someone here, maybe Ms. Blackman's wife or her other attorney, Mr. Carter, but I don't see them.
Yep, they are present in the courtroom, not sure
Oh.
why.
Thank you, Your Honor. Your Honor, I got a phone call just last week and indicating that Miss Adrika Blackman was in jail and that her bond was given a no bond. I tried to do some due diligence to find out why she didn't appear on my cases. And I talked to her wife, who indicated that her failure to appear was because she was in the hospital. I was trying to get those verification of that, but because of PISO, I was not able to verify that. But she indicated to me that, and then I talked to Ms. Blackman. Ms. Blackman indicated that the jail actually has her proof that she was in the hospital. And right now she's having some medical issues in the jail. So I was hoping I could address bond in this matter regarding her.
I don't know if you saw my afternoon docket. It's gonna fall at the very end of that docket because I've got, I don't even even see half of the people that are sitting in here waiting right now, and then we have to pull the file. So we can't cut line to get that addressed, because I need to pull the file. I don't even know why she has a no bond. It's not on this file, obviously.
No, it's on a felony file.
Okay.
Her failure to appear at a preliminary exam.
Got it. So
And
we can
that's-
pull that file and then I can try to get it in when I get this courtroom cleared a little bit here.
Sure, and I didn't mean to jump line. I just realized that she was in jail and she was being heard today, and I thought I.
No problem. Mr. Bigelow, I think, went to go grab the file, so we'll go on the record on that after I have the opportunity to review it. It's a bit of a wild mixture going on my document right now. I got some city attorney cases, some
Sure.
civil motions, looks like some LT. I don't know what's going on here. Thank you. So hang tight, Ms. Blackman. We'll get to the other matter in just a moment. Dennis Connor. Do you have an attorney? You're muted. You're muted, Mr. Connor.
Oh, yes, sir. I'm sorry. Yes, ma'am.
Okay, do you have an attorney?
No, ma'am.
Okay, you're on the record in the matter of the people of the city of Lansing versus Dennis DeAndre Connor. File number is 17-00975. This was the date and time set for sentencing. Back November 26, 2019, you pled guilty to count 5, a failure to pay income tax. And you were sentenced to a delayed sentence under 771.1, giving you a year to make payment in full of the amount of $1,368.44. And if you were to do that upon your sentence date, the city was willing to dismiss. Your sentencing date was scheduled for November 30th, 2020. You failed to appear. And so here we are, 2 years after your actual sentence date, but 3 years after the date of the plea. So I'm confident that you paid in full, correct, sir?
No, ma'am, I haven't actually.
Oh, okay. How much does he owe?
I got pulled over and I paid $500. I don't know if that was gonna go towards it or not. But it kept me from going to jail. So I don't know if that's gonna go towards it or how that works.
1,518. 44 cents. Can you send that our way? No, you owe $1,518.44. You said you posted a cash bond when you got pulled over,
Yes, ma'am.
the interim bond. It's in your name?
Yes, ma'am.
Why didn't you pay according to your agreement, even though you had 2 additional years?
Honestly, I just forgot about it. Just doing a lot of working, 2 kids. I really just forgot about it till I got stopped. And then he told me, I was like, oh, and then I remembered. And then so the sentencing, I actually didn't know I was supposed to come to a sentencing. I just thought after I made the arrangement that was it. And then so until I got those warrants again, until he stopped me and I found I had warrants again.
Yeah, we gave you a sentencing date, sir, and then you failed to appear. Nonetheless.
Yes, ma'am.
We also 6 months after, I'm sorry, months before, 3 months before your actual sentence date, we mailed you some Zoom instructions, which would have been a reminder. Nonetheless, we'll proceed with your sentencing at this time. You're ordered to pay $1,518.44. That includes the past due income tax amount, plus it includes a $75 crime victim rights fee, a $25 state minimum cost. I'm going to assess a fine of $250 on top of that. I'm going to apply the $500. So that means you will still owe a balance of $1,268.44. When are you gonna make your next $500 payment?
Can I come set up payment arrangements? Like come to the
Yeah,
court somehow?
That's what we're doing. That's what we're doing. We're gonna do it since you walk around with $500 on you. So when you
I
get
don't,
pulled
I
over,
had to,
you
I
must,
had to
you
call
must be
somebody.
safe.
Oh no, ma'am, I had to call somebody to bring it to me. My mom brought it to me and then I just paid her back. I had it on the debit
Okay.
card. He wouldn't accept debit card.
Right, but my point is that you had it available, but you had this money lingering that you owed and you didn't remember to pay it. So we're gonna help you remember to pay it by setting up payment plans in the amount of $500.
Okay.
When are you gonna make your next payment, sir?
I guess when I get $500, I don't just have $500 like that. My daughter's birthday was the next day. That's what I was saving it for. The day I got stopped was the 21st. My daughter's birthday was the 22nd. They were saving it for her party.
And you're employed?
Yes, ma'am.
Where are you employed?
I work at RSDC.
Okay. How often do you get paid there?
Every 2 weeks.
Okay, how much are you gonna pay every 2 weeks?
I could put 100 every 2 weeks on it.
When's your next pay period?
I get paid next Friday.
Friday the 9th or the Friday after that, sir?
I believe this week is the 9th. Yes, ma'am. So it'd be the week after.
16th?
Yes, ma'am.
Okay, I'll put here that you're gonna pay $100 every 2 weeks, beginning December 16th, okay, sir?
Yes, ma'am. Thank you.
No problem, so long as you're compliant with that, you will not get a show cause or a bench warrant issued. However, if you find that you need to make different arrangements because this one's not working out, it's your responsibility to contact the court. You can't just blow it off or say you forgot, because that doesn't help you. You don't want to be sitting in jail for Christmas because you failed to make the payment. You understand?
Yes, ma'am.
Okay, do you have any questions at this time?
No, ma'am, I don't.
Okay, well, then that's the order of the court. As to your sentence, you have a continuing balance of $1,268.44. You'll pay $100 every 2 weeks, beginning December 16th until paid in full. That's the order of the court. You're all set, sir.
Thank you.
You're welcome. Okay, Robin Frederick. Robin Frederick, is she back? She is there. Are we having a hearing?
No, Your Honor.
On the record in the matter of the people of the city of Lansing versus Robert Renee Frederick, file number 21-02786.
On behalf of the city of Lansing,
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Robin Frederick, who is appearing separately by Zoom.
Ms. Frederick has a considerable amount of background noise going on. Are you able to go to a quiet, a more appropriate space for court?
Yes, I just did.
Okay, very good. Today's the date and time set for a probation violation hearing. I have here. I have here a request and summons for probation violation. It alleges that Ms. Frederick allegedly committed the technical violation number 14 by failing to submit to a random drug test. And this was on multiple dates, that being on August 18th, August 27th, August 23rd, September 3rd, all in the year of 2022. And so this matter was scheduled for a hearing today because she was previously arraigned and pled not guilty. You're indicating, Ms. Donnelly, that she does not wish to have her hearing today, so she wants to plead guilty to the violations?
Yes, it's my understanding that she doesn't dispute the allegations. It would, there obviously is an explanation for why she didn't test those days, but she does not dispute and should be pleading guilty.
Okay, Ms. Frederick, is that correct?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do, Your Honor.
Thank you. You can put your hand down. Okay, and Ms. Frederick, you understand that you do have the right to have a contested hearing on this violation?
Yes,
You understand that the purpose of the contested hearing is to have the probation department and the city attorney bring forth sufficient evidence to establish their burden that you violated the terms and conditions of your probation. You understand that?
yes, Your Honor.
Okay, and you wish to waive that hearing today?
I do.
Anybody threatening you to get you to waive your hearing?
No, Your Honor.
Are there any promises being made to you in exchange for you waiving your hearing today?
No, Your Honor.
You understand that if you are found to be in violation or if you plead guilty to the violation, that I can either continue your probation or I can sentence you to a term of jail time, I could impose fines, or I can add additional sanctions to your oversight. You understand that?
Yes, Your Honor.
Okay, as to the violations that you failed to submit to testing as ordered, back on August 18th, August 27th, August 23rd, and September 3rd, how do you plead, ma'am?
Guilty, Your Honor.
Ms. Donnelly, can I have a factual basis?
Thank you, Your Honor. Ms. Frederick, as a term of your probation, were you told that you to submit to random drug testing?
Yes,
And at least back in August, were you ordered by your probation officer to test 4 times a month?
yes,
All right. And did you know that you had to test on August 18th, 23rd, 27th, and September 3rd?
it was random. I received a message that morning, yes,
All right. But you did not submit to a random drug testing?
correct. I didn't have the funds.
All right. So, okay. So you knew you had to test, but you couldn't pay for it.
Correct,
All right. And are you still having that issue that you can't pay for testing?
correct.
You're still having that. So have you been able to test since September 3rd?
I just got my check turned back on, but I have tested since then. But not every time.
And as every time is because you can't pay for it?
Yeah, because my check was cut off. But like I said, I just got it cut back on.
All right. Your Honor, I have no further questions.
Any questions from the city?
Nothing from the city, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea if I can be made freely, voluntarily, and intelligently. Recommendation of probation is to continue your probation status. It says that your treatment compliance has been satisfactory. It did note here that the stress factors that were notable were your finances. So at this time, I'm going to continue your probation. I recognize that you were ordered to make monthly payments on your probation. I think the last payment was made back in August. I want you to prioritize those drops for this next remaining month or so that you don't get any violations, ma'am. I would love to be able to discharge you without having to continue you, but I need to see what's going on in your blood. You understand that?
Yes,
Okay. Do you have any questions at this time?
no, Your Honor.
Okay, well, continue on your probation and again, prioritize your testing and hopefully we can discharge you on January 25th. Any additional matters for the record?
None for defense. Thank you.
For the city.
Thank you. You're all set, ma'am. Thank you.
Thank you.
You're welcome. Okay, and Mr. Cervantes, are we having a hearing on him?
No, Your Honor. I don't believe Mr. Cervantes disputes the allegations either.
On the record in the matter of the people of the city of Lansing versus Bernardo Cervantes Jr., file number 21-03518, council appearance.
Matt Staples on behalf of the city of Lansing.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Bernardo Cervantes Jr., who is appearing separately by Zoom.
Okay, today was the date set for a hearing on a probation violation. I have a request and summons for probation violation upon which Mr. Cervantes was previously arraigned. The violation alleges that he violated the terms of his probation by committing the technical violation number 6 of failing to pay fines and costs. The amount due was $246 as of September 26, total due being $736.18. There is a technical violation that he tested positive for alcohol on September 6th, September 21st, and October 21st, 2022, and that he tested positive for cocaine on September 6th, 2022 per positive lab confirmation. And Ms. Donnelly, you indicate your client wants to waive his hearing today and plead guilty to the violations. That's correct, Mr. Cervantes?
Yes, Your Honor. Hope everything was good with you and that you had earlier.
Can you raise your right hand? Can you
Yes,
raise your
ma'am.
right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. Okay, Mr. Cervantes, you have the right to have a contested hearing on these allegations that you violated the terms of your probation. The purpose of that hearing is so that the prosecution, which is the city, as well as your probation officer, can bring sufficient evidence to support the allegation that you violated the terms of your probation. You want to waive that hearing today?
Yes, Your Honor.
Anybody threatening you to get you to waive your hearing and plead guilty to these violations?
No, Your Honor.
Were there any promises made to you in exchange for you pleading guilty to these violations?
No, Your Honor.
Okay. You understand that a guilty plea means that I could potentially sentence you to increased sanctions or to jail time, or I could even increase or extend your probationary term. You understand that?
Yes, I do, Your Honor.
Okay. As to the violations that you failed to pay fines and costs, the amount due as of September 26th is $736.81. How do you plead?
Guilty.
As to the technical violation that you tested positive for alcohol on September 6th, September 21st, and October 21st, how do you plead?
Guilty.
And as to the technical violation that you tested positive for cocaine on September 6th, 2022, how do you plead?
Guilty on that, Your Honor.
All right, can I have a factual basis, please?
Thank you, Your Honor. Mr. Cervantes, as a condition of your probation, were you ordered to make payments on what you owe?
Yes, I was.
All right.
I was making sure my my other stuff, my other bills and other stuff or meetings like outpatient for Pats was paid before that.
Okay, so have you been able to make any payments?
Not to the court system at this moment.
And then also, as a condition of your probation, you were ordered to refrain from using illegal drugs and alcohol, correct?
Correct.
All right, and so on September 6th, September 21st, and October 21st, did you knowingly ingest alcohol?
Before those dates, yes, and then got tested, yes.
Okay, so on or about those dates, you used about how much alcohol, and what are we talking about? What kind of alcohol?
Just like a half a pint of alcohol. But the way the testing goes, I knew better.
Okay. And then did you knowingly use cocaine around September 6th?
Yeah, Labor Day weekend.
Okay.
No, it was wrong.
All right, you're under no further questions.
Any questions from the city?
Nothing from the city, Your Honor.
Okay, I find the factual basis sufficient. I'll accept your plea. I find your plea be made freely, voluntarily, and intelligently. The recommendation really just says that the court's discretion, but they are requesting to add some inpatient treatment and a scram. Did you want to address the court before sentencing, Ms. Donnelly?
Thank you, Your Honor. The recommendation includes a scram tether if the court decides that he's not going to go to inpatient treatment. At this time, since these violations, well, the recommendation is partially, I believe, based on the fact that there was, after the that use, a referral from Pat's or a recommendation that Mr. Cervantes Jr. do inpatient programming. I believe that was at a point in which he was had only started doing intensive outpatient programming. He had one session under his belt when he relapsed and used again. But at this time, since then, Your Honor, he has he's still testing, he's refraining from substances, and he's doing intensive outpatient programming. He's gotten himself a sponsor and he's doing groups. So I believe that at this time, the inpatient might be unnecessary at this time if the intensive outpatient is working. So we would be asked to continue that. But other than that, Your Honor, we would have no objections. We just want him to be continued on probation. So if means increased testing or a scram tether, he has no objection to that, Your Honor. He just has his job right now that's paying for the programming, and I believe he also owns his own home, supports his family. So he's just worried about losing his job if he has to do intensive or if he has to do residential. But he believes that, and I think that the intensive patient's being intensive outpatient is being effective right now. So we only be requesting, Your Honor, that it be continued on that with either higher testing or scram or some other penalty like extension or something. I'm sorry. That's it, Your Honor. Thank you.
Okay, sounds good. I'm going to continue his probation. I'm going to extend it an additional 3 months. He was supposed to be discharged March 27th. I'm going to have him continue until June 27th. I'm also going to add the scram tether. He is ordered to continue his intensive outpatient programming and continue to follow all the additional orders of the court as it relates to his probation. Fines and costs still, I think, owed on this matter of $736.81. He can make payments on that, but my primary concern is his overall health and wellness as it relates to the substance abuse. Do you have any questions today, sir?
No, you're one question. So we're continuing the drops plus the scram and everything else, correct?
That's correct.
Okay. Thank you, Your Honor.
No problem. Any additional matters for the record, counsel?
No, Your Honor. Thank you.
Nothing for the city, Your Honor.
You're all set, sir. Thank you.
Thanks, Your Honor. Have a good day.
Same to you. Know what happens to Mr. Carter? Carter leave. Okay, let's see.
Yep. Can you hear me now? Officer, she can't hear me.
on the record in the matter of Mississippi State University versus Ronald Gordon, file number 15-01794 GC. Council appearance.
Good morning, or good afternoon, Your Honor. May it please the court, Dominic Silvestri, P65275, appearing on behalf of the plaintiff.
Okay, I don't know if there's a Ronald Gordon here. I've got about 50 people on my Zoom right now.
Your
Ronald
Honor, I've been
Gordon,
I'm sorry.
present. Yes, you're fine.
I was just going to say I've been monitoring the participants. I haven't seen him appear yet, but I wasn't sure if he was in the courtroom with you.
Anyone in the courtroom by the name of Ronald Gordon? The defendant has failed to appear. The request for installment would be denied at this time. And let's see here.
Wow. Yes. Yeah.
We did provide an order. I'll sign and date it for today. Any additional matters for the record?
I'm sorry, Your Honor, you broke up. Do you want me to provide an order denying his motion for
No,
installment
I do
payments?
have an order. I have an
Oh,
order
okay.
here.
Okay,
I'm gonna sign
That's
and
all I
date
have.
it for today, denying the motion.
thank you. Have a good rest of your day, Your Honor.
Same to you. Did you give me your email? It's not really showing up for me. Sure. Okay, sounds good. It's Lorenzo James here.
Yes, ma'am.
Very good. We're on the record in the matter of the people. I'm sorry, it's a civil matter. We're on the record in the matter of Lafayette versus Lorenzo James, file number 17-04606 GC. Council appearance, please.
For plaintiff Lapku, Tim Smith, P48259.
Okay, and so this date was set as a control date. I don't know if, did you all need to meet privately or do you know how you need to proceed at this time?
Well, the court was kind enough to give Mr. James some time to produce certain documents that were responsive to your subpoena. Those documents were explained to him the last time we were together. He sent nothing. Don't understand why. Maybe he can explain to us why we're still waiting on documents. There was no reason to be here today. If he produced them, we'd be done with it.
James?
I do have the bank statement that has 0 transactions on it. It cost me more to send that to you than it would anything. So, I mean, I showed the last guy that, and I can still send it. And the IRS is toying around with my tax returns. So, I mean, if you can get them faster than I could, I mean, I would definitely appreciate that, but I can't get them any faster.
Well, if the IRS has the return, that means you prepared one and filed it. So all you need to produce is a copy of what you prepared and filed with the IRS.
I don't have any more copies. So I'm waiting for them to send me a copy. So when they send me a copy, that's what I can send to you guys. And right now they're telling me that they don't know who I am. They can't confirm my identity.
Yeah, that would be a problem. Do you have the last 6 months of bank records in your possession?
Not currently. I'm in the car, but I got them at home and there's nothing in there. It just shows a $5 deposit that I had to do to get that statement that showed $0 for the past 2 years.
The issue doesn't have anything to do with how much is in the account. The judge ordered you to produce 6 months of bank records. So, Your Honor, I guess what I would suggest is we give Mr. James 30 days to put 6 months of bank records and his tax statements into my possession, as he was told to do last time. If he fails to do that, we can address that issue next time we're before you.
Mr. James, are you clear that you need to provide those bank records? This is an order of the court for you to do that. You do recognize that, correct?
Yes, ma'am. I can go and try to ask my grandmother for a few dollars to see if I can fax this paper over to them just to prove my point. But I will also get the...
Do you live in Lansing, sir?
Yes, ma'am.
Okay, why don't you bring them to the court and we can get them for them, so you don't have to borrow any money from your grandmother. How about that?
I appreciate that. I would definitely do that. And I only have the bank statement that's indicating what was in my account, which is nothing. That's the only paper that I have. And the
What's ordered?
IRS,
That's
the
fine.
IRS,
He needs to see that, okay?
absolutely, he can have it.
Just so that we're
Okay,
clear,
so
Your
you-
Honor, we do need
Yes.
6 months of account statements so that we can assess account activity over the last 6 months. That's what was ordered on the subpoena. Not a
Absolutely.
statement from today showing present balance.
No,
Okay.
this paper goes back 6 months. You want me to do a year for you?
Nope, judge said 6
Okay.
months. I just want
Absolutely.
you
This
to
paper
confirm.
does, this paper does take 6 months, to the best of my knowledge. That's the one that I requested when I showed up to the branch. They went back 6 months, half a year.
Okay, sounds good. So we'll order that you get that to the court within the next 30 days. And
I'll
then
walk
we
it up
can,
to you as soon as I get back to the house, Your Honor.
that'll be phenomenal, and then we can get it scanned into Mr. Smith.
Thank you, ma'am.
Okay, any questions today?
None from the plaintiff, Your Honor?
Once I
Reset
submit
the
this paper,
control- I am gonna reset the control date on this, but
Thank
you had a
you.
question, Mr. James?
I just wanted to know what was the next step after I submit this form.
Once we've had an opportunity to review the documents the judge ordered you to produce, we can chat about what the next steps could be. Okay?
Absolutely.
Okay, 30 days out. It'll be January 5th at 8:30 in the morning.
Thanks, Your Honor.
15.
The 5th, 05.
Thank you.
Oh, okay, then you're all set for today, sir. Thank you.
Yes, ma'am. Thank you very much.
No problem. We're on the record in the matter of the people of the state of Michigan versus Adrika Blackman, file number 22-00826, apply. Council appearance.
If you please, the court, David B. Carter Jr. on behalf of Miss Blackman.
Okay, and this matter, Ms. Blackman is present. She can hear us clearly. She's viewed through. This matter is before me on a bond. It looks like Ms. Blackman failed to appear on this matter back September 1st. And the reason why there's no bond is because I remanded her because she's failed to appear multiple times and there had been no communication with her attorney. And so you indicate that she's been in the hospital?
That is my understanding, Your Honor, and as I indicated earlier, so I'll make a record for this recording, is that I tried to do my due diligence and get verification of that. And because of the HIPAA law and my client being incarcerated, I was not able to verify that. But I did verify it with her spouse, who is present at the courtroom. She indicated that she was going through a series of medical issues. She's been in and out of the hospital. She's actually suffering from some medical issues in the jail. She indicated to me, and I talked to Miss Blackman, and she indicated that the jail actually has her medical information there, that she was in the hospital, but I understand that that's not here in front of me today, but that's the best due diligence I could do in this short period of time.
Okay, but you now have good communication with your client, is that correct?
I do, matter of fact, to say tongue in cheek, I lectured quite a bit with my client. I also lectured the spouse, how important it was for them to communicate with me. There was a mix-up, according to them. They indicated that they had thought when I was in here last and I got what I was communicating with her, I was here. I stood in front of Your Honor on the other pretrial, the misdemeanor case, and indicated for her to call her misdemeanor attorney. And from that point, they thought I was passing the whole case on to her. But I do have a series of messages from Ms. Blackman since this had been discovered, and at least from her spouse, because she's been in jail, and I believe I do have good communication.
Okay, very good. What's the good number for you, Ms. Blackman?
517-214-0651, ma'am.
Okay, bond will be amended to $5,000 personal recognizance. You need to follow all bond conditions that were previously stated. Stay in communication with your attorney And we'll see you at your next court date. Looks like you're scheduled for preliminary examination December 16th at 8:30 in the morning in person at the court. Do you have any questions?
No, ma'am.
Okay, good luck to you with your health, okay?
Thank you so
Thank
much,
you.
Your Honor.
Thank you. Let's see here. We're on the record in the matter of HZ CNAC Inc. versus Jacqueline Johnson, file number 21-02772 GC. Counsel parent.
Good afternoon, Your Honor. Tyrone Freeman on behalf of the plaintiff, HZCNAC.
Okay, I see someone named Jackie. Is that Jacqueline Johnson?
Yes, ma'am.
Okay, very good. This was the date and time set for a hearing on an objection to motion for installments payments. And Ms. Johnson, you must have filed a motion for installment payments, which you did. Looks like it's dated for November 10th. You indicated that your average income is about $215 every week. And then you highlighted what your bills were. You were seeking to make payments in the amount of $25 every 2 weeks, and you don't want to even begin for another, well, it'll be about 3 months from the time you filed this motion. Is that correct?
Well, I can start like paying like in January or February. I was expecting to go back to work full time, but right now I'm only working part time. I'm only working 4 hours a day at Centria Austin. So financially, like I'm kind of struggling right now, kind of pushing it, trying to start that, but I just need a little time to get caught.
Okay, were you previously making payments on an installment plan?
Yes, ma'am. I was previously making payments, and it was about a year or two ago. I lost my fiance and dad in an accident, and it was just something that I kind of like. It kind of, you know, I want to say forgot about it, but it was something that I did put to the back burner, back to pick back up on this. I just don't give.
Okay, so what you're indicating is that you're currently not experiencing full-time hours. Is that what it is?
No, right now I'm working 4 hours a day at Centria at Autism. So like I work about 16 to 20 hours a week. It's just I'm a 5 and I'm doing it by myself. So I'm not trying to make excuses for it. It's just financially right now, I'm just having a little trouble.
When is that gonna change for your hours? When does that increase?
Well, it's not, well, right now, those are the hours that I'm able to work, being that I single parent kids. So I'm hours that I'm available to be able to go work with my kids at school. So I don't. So I go to work after my kids get out of school. Our center is back open on Saturday now, so that's the day that I'm able to work full day.
Okay, based on what you're providing to the court, is that your income is only $215 per week, but that you pay $500 a month in rent. You pay $300 in utilities. You have a phone bill of $100. You have transportation bills, and then you said other household items about $200. That doesn't even equate to what you're telling me you owe. Do you have some other income, ma'am?
Yes, ma'am. I do hair. Like when I can't count it as go, but like I try to like side hustle on the side. So I'll try to like do hair, and then I also make balloons and things like that. It's just like little side hustles that I do to keep myself going.
Okay, I mean, I respect the hustle. What, you can't hustle up an extra $50 though?
I mean, I can, ma'am. I'm doing the best. Like I said, I got like 5 kids, so like I can.
I get it.
If
I completely get it. What I'm saying is, at the rate that you're trying to pay this off, everybody will be dead before it's paid off.
Well, if I can pay the $50 every 2 weeks, then that's fine. But I couldn't pay that a week.
Okay. And your request was to pay $25 every 2 weeks, but you think you could do $50 every 2 weeks?
Yes, ma'am.
Okay, that's what I'm gonna order. I'm gonna order that you pay $50 every 2 weeks. I am going to grant your request to start those payments February 1st, okay?
Okay.
And Your Honor, are you putting any type of review on that? I do see that $50 weekly, it would take 42 months. So at 52 biweekly, it's going to take 84 months. We're still stretched out there quite a bit, but I do understand she has a situation right now.
Yeah, I'm gonna go ahead and see what's going on in about 6 months. We can assess her financial situation. She may have, hit the lottery or something by then and may be ready to get this taken care of. I don't know. But I don't think she wants this looming over her head for the rest of her natural life.
Is there any way, because I haven't spoke to my brother in like 6 years. This was a card I co-signed for him and he bankrupt and it came after me. So this is kind of like how I got caught with the tab. It's like, so I'm, regardless of, it's still my responsibility, correct?
Yeah, that's the unfortunate part about co-signing. You're essentially saying if you can't get it from them, I'll take care of it.
Yeah.
That's why you should co-sign for people.
Yeah.
So yeah, it's the unfortunate situation there. Nonetheless, I am amending this order that was provided to indicate that she will make payments in the amount of $50 every 2 weeks. Beginning February 1st, we'll set it for a review in 6 months. I'll get you a date right now.
Okay.
At 1:30.
And Your Honor, I'd like to know somebody who wins the lotto. I don't even know anybody who's won the lotto. I'd be happy with that. I would hope.
I know of someone actually, not in the state, but June 6, 2023. At what time? 1:30. At 1:30 p.m. is what we're setting that for at this time. If that changes, we'll mail a notice to you in the mail.
Okay.
You have any questions at this point?
No, ma'am. Thank you.
No problem. Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you very much. Have a good day.
Thank you. Same to you. Happy holidays. Okay, let's see. Orbit Leasing versus Andrea Buff. You're Andrea Buff. Okay, you're here today for a pretrial. It looks like on a civil matter. I have this up for pretrial. Do you have a device that you can get on Zoom with?
I have my phone.
We'll get you on Zoom because the purpose of the pretrial is to go to create a joint pretrial statement. And we'll put you in a private meeting room with Mr. Chisholm so you all can create that joint pretrial statement, okay? Thank you.
Judge?
Yes.
Your Honor, Matt, I'm trying to figure out how we got here, Your Honor. This is a case that was a judgment was entered in this case back in March. I have not seen any kind of motion to set aside that judgment.
Yeah,
but
there was one back on April 18th. We had a hearing, April 18th, and it says, the defendant indicated to the court that she had signed a settlement before the lawsuit was filed back on October 29, 2021. I granted relief from the judgment based on possible mistake or misrepresentation. It was set for a pretrial.
Okay, thank you, Your Honor. I appreciate that clarification.
No problem. Okay, Cabrio Properties versus Nicholas Stewart.
Good afternoon, Your Honor. For the record, Stuart Collis on behalf of the plaintiff in this matter.
Is Nicholas Stewart present?
I have not seen him show up on Zoom.
I don't see anyone in the court responding to the name Nicholas Stewart. Today was the date and time set for a pretrial on a civil matter. It does appear, however, our notice that was sent for them to appear returned non-deliverable. Okay, we sent it to the address that was provided to us by the defendant at the time of his answer.
And Your Honor, the answer in effect admits the debt because he says he disagrees. He says, I moved out in March and I'm being billed for April and May because they were unaware I moved out prior, which is exactly why those months are due because we didn't have keys. So, so Your Honor, this time.
Default judgment will be entered.
Thank you. How do I get that to the court?
You can submit it to Judge Simmons courtroom at lansingmi.gov.
Judge Simmons courtroom
At lansingmi.gov.
at lansingmi.gov. Thank you so much, Judge.
Thank you. Have a good one.
You too.
On the record in the matter of South Washington Properties versus Geller Trading Company, file number 22-02241 LT. Council appearance.
Good morning, Your Honor. Jason Yurt on behalf of South Washington.
And Jeff Landon on behalf of Mr. Geller.
Okay, let me put Mr. Chisholm and Mrs. Buff in the room for a moment. Today was the date and time set for a hearing on a motion to withdraw attorney. Let's see here.
Mr. Landon just sent me over a stipulated judgment. I haven't had a chance to really look at it. So I think this matter is resolved if I'm not mistaken.
Mr. Landon was moving to withdraw as counsel. Does that not happen anymore?
Your Honor, I did file a motion to withdraw as counsel because I was not having any communication from my client. But as of a couple hours ago, I emailed both plaintiff counsel and the court proposed judgment for possession that my client did sign, although he did sign it on the wrong line. He signed it on the plaintiff's line. He is surrendering possession as of today. This is a possession only case. There's no money damages in this case. The plaintiffs have filed a separate case in the circuit court for money damages. That case being 22-768 CB, Ingham County Circuit Court. So I am aware that a escrow order was entered in this matter. I'm unclear on why that would happen when there's no money judgment being sought, but we believe that this is a possession only matter and this consent judgment resolves this case.
Okay, you're withdrawing your motion to withdraw because that's for the purpose of today's hearing.
Provided that the court is satisfied with closing out this matter, otherwise I'd like to move forward on my motion.
Yep, I'm happy to do that if you are stipulating to a judgment. I've noted that here on the file and I'll withdraw your motion to withdraw and we'll look forward to getting a copy of the signed judgment. You can submit that to Judge Simmons courtroom at lansingmi.gov.
Yeah, Judge, I'll have to take a look at it. I saw it in my email. I have not taken a look at it. I don't think if it's just a judgment for possession doesn't, there may be money damages as long as the box is checked that there may be additional money damages owed, which I did see. I just want to look at the judgment. I don't think there's gonna be a problem at all.
Okay, sounds good. I'll note that in the file and we'll look forward to seeing that. Any additional matters for the record?
Thank you. And Jeff, I'll get back to you later today or tomorrow morning, okay?
Sounds good. None from me, Your Honor.
Thank you.
No, Your Honor.
Thank you. You're all set.
Thank you.
Have a good one. This is the matter of Marvin McNeil versus and Jennifer McNeil versus Raul Lopez. File number 22-02411. What's your name, sir?
Raul Lopez.
Okay, and we do have an interpreter here, I believe.
Yes, I'm here.
very good. And then Ms. Till, are you representing Mr. Lopez?
Yeah, Felicity Till, P83961, appearing on behalf of the defendant Raul Lopez, who is with you in the courtroom.
So this was the date set for a pretrial. It looks like we did receive from you, Ms. Till, an answer, affirmative defense's countercomplaint and jury demand. So you all just need to complete a joint pretrial statement. Marvin McNeil?
He's not here.
Okay, what about Andrea McNeil?
That's not a person part
Sorry,
of the
Jennifer
case.
McNeil. Is it Jennifer
I'm here.
McNeil?
Yeah.
Okay, where is Marvin?
He can't connect.
You said he cannot connect?
Yep, he's having a problem connecting.
Okay, and you were proceeding without an attorney, correct?
Correct.
Okay, I'm going to put the parties in a private meeting room so they can complete their joint pretrial statement, or you can come to resolution if that works. Mr. Lopez, let me swear you in. Can you raise your right hand? I'm sorry. What's the
me?
interpreter's name?
Me? Yeah, I'm
Yeah,
here. Pablo.
someone put interpreter for Lopez, but I need your name. What's your name, sir?
Pablo Bello, Pablo
Thank you.
Bello.
Do you solemnly swear or affirm that you are interpreting the matter now before the court completely and accurately and not divulge confidential communication, so help you God?
Yes, I do.
Okay, thank you. I do think that I have a proposed pretrial statement from you, Ms. Till, but you probably want to go over that with them. Is that what's going on?
Yes, Your Honor.
Okay, very good. We'll get you on the private meeting room.
La juez dice que nos vamos a ir a un cuarto de descanso para que hable usted con la abogada.
Okay, I need to see what's happening here. We're on the record in the matter of Anmark Rivershell Apartments LLC versus Tangi McQueen, file number 22-02447 LTE. Appearance, please.
Good afternoon, Your Honor. Corey Grand Mason appearing on behalf of the landlords.
Is anybody present on behalf of Tangi McQueen? Let me see. Who just joined from an iPhone?
Anthony Basinger.
Let's see. Okay. This was the date and time on this matter to address a motion to reinstate case. This matter was dismissed by motion back on November 2nd. The motion to reinstate indicates that was, or the case against Ms. McQueen was dismissed in error. Is that correct?
Yes, just the name simply wasn't changed. They had the correct case number, which was for a different resident over at River Shell. And we're just simply trying to get it back on the docket without having to refile a new case.
Okay, looks like we dismissed this on the 2nd, and within 7 days, we received your motion. I will grant your request and reinstate the case as to Tangi McQueen. And we'll get that set for a pre-trial.
Okay.
Civil Department will set that for a pre-trial. You'll get a notice in the mail, okay?
Okay, I just wasn't sure if you had the ability to get a hearing date at this time. If not, we'll be looking for it. Thank you, Your Honor.
Thank you. You're all set. Okay. I think that takes care of all of this.
Court. Nice, I'm on court.
Bernard Poe. Can you hear me, Mr. Poe? Okay, you're muted. You have to unmute. Who's representing Mr. Poe?
Assistant Public Defender John Lee.
Okay, do you need to speak to him at all privately?
No, we're all set to go, Your Honor.
We're on the record in the matter of the people of the city of Lansing versus Bernard Deshaun Poe, file number 22L2678951, council appearance.
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Mr. Pogue, who is appearing via Zoom.
Today's the date and time set for a pretrial. This matter was adjourned to allow the defendant to try to get his license. How are we proceeding at this time?
Mr. Pogue has attempted on a couple of different occasions to take the test, but has been unsuccessful. Most recently, he has been dealing with a death in the family, and so has not had an opportunity to go back and retake the test. We are asking, Your Honor, for a 30-day adjournment to give him a chance to retake the test and see if he can pass it.
Okay. And January 10th at 9:30 will be the new date, okay?
Thank you, Your Honor.
No problem. Any questions for the court today, Mr. Poe?
No.
You hear? Okay, well then we'll see you on January 10th at 9:30.
Okay, thank you.
Is Carrie Horton here? This is the matter of LAFQ versus Carrie Horton, file number 15-01646 GC, council appearance.
For plaintiff LAFQ, Tim Smith, 48259.
This was the date and time set for hearing, I'm sorry, a discovery hearing. It looks like the defendant did appear back on October 17th. He was ordered to provide documents within 45 days. This matter was set for the control date but she's failed to appear. Did you get those documents?
I did, Your Honor, but the bank statements in particular created more questions than they answered. I was hoping she was going to appear today. She had testified as to a singular source of income. The bank records revealed other deposits, cash deposits, ATM deposits coming in. It looks as if she's got, to borrow a phrase from an earlier defendant, side hustle going on. I was hoping she was going to appear today so I could get some understanding of that income. She may have thought that because she sent things that she didn't have to appear today. In fact, she was probably told that at the last hearing. What I would suggest or ask the court, if we could notice this up again for a new hearing date, mail it to her address so that she has notice that she does need to appear. I've been unsuccessful trying to contact her to get answers to the questions raised in her bank statements. So I really don't want to ask for a bench warrant today. Let's give her a chance to appear and have a better understanding of what's going on with her bank account and her income.
I would agree with that approach. We'll get this set for a new hearing date and we'll notice her for appearance on that date.
All right, appreciate your help. That's my last one. Have a great day, Your Honor.
Same to you. Have a good one.
You as well.
January, I was trying to see if I can do it for this one. Oh, no, no need to try to do that. It'll be January 3rd at 1:30. Castaneda, arrived, got present. I don't see anybody.
Your Honor, I do believe that he is present. It's Eduardo Castaneda Arriaga.
And Your Honor, this is Maria Cox. I'm here as a Spanish interpreter for Mr. Arriaga Castaneda.
Okay. I see iPhone de Edward. Is that who Mr. Arriaga is?
I'm here.
Señor Eduardo Castañeda, ¿necesita intérprete?
Sí.
Okay. He says he does need an interpreter, Your Honor.
Thank you. Ms. Donnelly, do you need to speak privately?
Your Honor, no, I should not be able to speak privately because we've spoken before and it's my understanding the city is dismissing this.
Dice su abogada que ella no necesita hablar con usted porque lo que ella entiende es que su caso, la ciudad lo va a anular.
Okay.
The city will be dismissing as this was filed under the wrong, essentially law, Your Honor.
Sounds good. This case is dismissed.
El caso ha sido anulado porque la ciudad puso los cargos bajo una ley incorrecta.
Okay.
Okay, thank you, Mr. Arriaga. Thank you, Ms. Cox.
Gracias, señora Arriaga. Gracias, señora Cox. Thank you, Your Honor. Have a good evening.
Thank you.
Thank you.
Bye-bye.
Taylor Jungle.
Yes, I'm here, Your Honor.
Okay, Ms. Donnelly, are you representing Taylor Jungle?
Yes, Your Honor.
You need to speak privately?
No, we did, Your Honor.
Okay, we're on the record in the matter of the people of the city of Lansing versus Taylor Rose Jungle, file numbers 22L2705581, 582, 583, council appearance.
Matt Staples on behalf of the city of Lansing.
An Assistant Public Defender, Sarah Donnelly, on behalf of the defendant, Taylor Jungle, who is appearing separately by video.
Today was the date and time set. Okay, for hearings on each of these matters, how are we proceeding on these?
Your Honor, at this time, Ms. Jungle has provided me proof that the title was transferred on the vehicle. I provided that to the city attorney, who is willing to offer that Ms. Jungle could admit responsibility to the too close and following too close with an accident in file 22L2705581OI. And with that, they will dismiss the other files.
That's correct.
That is correct, Your Honor.
Okay, your client wants to admit responsibility to following too close. accident?
That's my understanding, yes, Your Honor.
Is that correct, Ms. Jungle?
Yes, that is correct, Your Honor.
Okay, your fine is $135. When can you pay?
If you could give me at least a month, I can have it paid off completely.
I'll note here, you'll pay in full within 30 days. You can make payment on the court website if you use your case number. That's the case ending in 581 on this particular file. Or you can send a check or money order to the court, or you can come and pay in person at the criminal traffic window, okay?
Okay, thank you very much.
No problem, you're all set.
Thank you. Have a good one, Your Honor.
Same to you. Lake of Hills versus Evie Titus and Tyler Allen, file number 19-01181 GC. Anybody here on those matters? I don't see anybody. I don't even see the plaintiff's attorney. Do I see Mr. Hintz today? Okay, there was no service party still. Okay. This is the matter of United Guarantee versus Tammy Snyder, file number 21-02647. I don't see an attorney Schultz present on that one either. Neither party appeared last time either. That's what it looks like to me. MPC Cashway Lumber versus Brandy Day and Titanium Builders LLC, file number 22-01800 GC. I do see Brandy Day present, and I see Mr. Haynes also present. Okay, and this is the date and time set for a discovery. Do you need a private meeting room to do your creditor's exam?
That would be helpful, Your Honor.
Okay, Ms. Day, can you raise your right hand? You solemnly swear or affirm the testimony you're going to provide is the truth and the whole truth under penalty of perjury.
I do.
Okay, thank you. We'll have you placed in a private meeting room, okay?
Thank you.
No problem. Okay. Did you put them in a private meeting room? Sounds good. We don't have a file here for Megan. Oh, there's a motion for me today? Is that what you're saying? Who was supposed to remind me of it? Because I've been on vacation. Oh. Yeah, thank you. You said it, you're supposed to remind me, so I don't know what's on the date. You gotta get the file. Okay, we're on the record in the matter of the people of the city of Lansing versus Ramona Hunter, file number 22-02782. Council appearance.
Matt Staples on behalf of the city of Lansing, Your Honor.
Your Honor, Assistant Public Defender Sarah Donnelly on behalf of Ms. Ramona Hunter, but I need a breakout with her before we go on the record.
Okay, no problem. I also see Anthony Bassinger. Are you representing?
I believe that's
Anthony
Mr. Lee.
Okay, sounds good. Put you in a private meeting room now. Actually, let me put her in room 3 because Mr. Donnelly's already in room 3.
Yeah, let me tell you. Bye.
Sandra, you should have received a request to join the breakout room.
And I tapped on join, so I don't know what the problem is. I did tap on join though.
Okay, let me see if I can move you.
Thank you. Now I'm tapping.
Mr. Lee, did you need to meet with Mr. Bassinger?
No, Your Honor, we're ready to proceed.
We're on the record in the matter of the people of the city of Lansing versus Anthony Ray Bassinger, file number 22-02879. Council appearance.
Matt Staples on behalf of the city of Lansing, Your Honor.
Assistant Public Defender John Lee on behalf of Anthony Bassinger, who is appearing with us via Zoom.
Okay, Mr. Bassinger needs to start his video. Okay, very good. Today was the date and time set for a pre-trial on one count of discharging a weapon. How are we proceeding?
We are prepared to plead guilty to the charge, Your Honor.
Is that correct, Mr. Bassinger?
Yes.
Can you raise your right hand?
Yeah.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can put your hand down then, sir. You're being charged with one count of discharge a weapon in public. It's a misdemeanor. Maximum penalty is 90 days in jail and or $500 in fines. You have the right in this matter to proceed to a trial. You have the right to have a jury trial. At the time of trial, you have the right to be represented by counsel. You have the right to the presumption of innocence, meaning you are innocent until proven guilty. You have the right to have the city bring sufficient evidence to prove each element of the charge being brought against you. They have to prove each element at trial beyond a reasonable doubt. You have the right to see, hear, or question any witnesses that they intend to call, and you have the right to call your own witnesses or present evidence that you believe would further aid the defense to this charge. You have the right to remain silent at trial and not have silence be used against you. In order to enter a guilty plea to the original charge, you have to give up all of those rights today. Is that what your intentions are?
Yes.
Okay. Anybody threatening you to get you to waive your rights and plead guilty?
You said what?
Did anybody threaten you to get you to want to waive your rights today and plead guilty?
No.
Were there any promises made to you in exchange for you waiving your rights and pleading guilty?
No.
And are you pleading guilty because you believe you are guilty?
Yeah.
Are you currently on probation or parole?
Nope.
You understand that a guilty plea could result in a conviction that may have impact on any immigration status you may be seeking.
Yes.
You also understand that a guilty plea could have impact on your current employment status, or you may need to put a criminal conviction on your future job applications. Do you understand that?
Yes.
Okay, as to the count of discharging a weapon in public, how do you plead, sir?
Guilty.
Have a factual basis, please, counsel.
Thank you, Your Honor. Mr. Bassinger, on or about March 3rd of 2022, were you at a Speedway gas station located at 1201 North Larch Street?
Yes.
And that gas station is located in the city of Lansing, county of Ingham, state of Michigan, correct?
Correct.
And did you at that time fire 2 shots from a Smith & Wesson 9mm Luger pistol at a car that was being driven away by somebody who was stealing that car from you?
Yes.
I believe that's the factual basis, Your Honor.
Any questions from the city?
Nothing from the city, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing date is going to be February 7, 2023 at 8:30 in the morning. Prior to sentencing, you need to meet with probation, Mr. Bassinger, so you need to turn yourself into probation no later than Wednesday, 3 p.m. so that they can prepare you to have your pre-sentence report provided, okay?
All right.
Your sentencing will be via Zoom. Do you have any questions for the court today?
Will I be getting any like paperwork or anything on where to go?
No, you need to come to the probation department, which is at the court on the 5th floor.
All right,
And then you will get a notice in the mail with your next court date though. But
all right,
you need to have already been turning yourself into probation no later than Wednesday of this week. Okay, sir?
all right.
Do you have any other questions?
Nope.
You're all set for today. Thank you.
All right, thank you.
Okay, who's representing Ms. Rebecca Radicia?
I do represent Ms. Verdicia, Your Honor.
Okay, sounds good. And Ms. Hunter, I think is back here. Let's handle her first one. The record in the matter of the people of the city of Lansing versus Ramona Hunter. This is in file number 22-02782, council appearance.
Matt Staples on behalf of the city of Lansing, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Ramona Hunter, who's appearing separately by Zoom.
Thank you. Today it was the date and time set for a pre-trial. For 1 count of open alcohol.
Your Honor, at this time, I don't believe there is an offer from the city. Ms. Hunter is currently in treatment in Bear River, and she would be accepting all responsibility and pleading as charged.
Okay, Ms. Hunter, is that correct?
Yes, ma'am, it is.
Okay, can I have you raise your right hand, please?
Yes, can you see it? It's kind of hard.
Barely. Okay, do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down, ma'am. Okay, Ms. Hunter, you have the right in this matter to proceed to a trial. You're being charged with 1 count of open alcohol in public, and that's a misdemeanor. Maximum penalty 90 days and or $500 in fines. At the time of trial, ma'am, you have the presumption of innocence. So you're innocent until proven guilty. You have the right to have the city meet their burden of providing sufficient evidence to prove each element of the charge against you beyond a reasonable doubt. You have the right to see, hear, or question any of the witnesses the prosecution intends to call. You have the right to call your own witnesses at trial or present evidence at trial you believe would further a defense of the charge. You have the right to remain silent at trial and not have silence be used against you. You will need to give up each of those rights today, ma'am, if you want to plead guilty to the charge. Is that what you intend to do? Give up your rights? Anybody
Yes, I
threatening
do.
you?
Yes, ma'am, I do.
Okay, is anybody threatening you to get you to want to give up your rights today and plead guilty?
No, ma'am.
Has anybody made any promises to you in exchange for you giving up your rights and pleading guilty?
No, ma'am.
Are you currently on probation or on parole?
No, ma'am.
You understand that a guilty plea could result in the conviction that you may need to report to your current employer, or you may need to put a criminal conviction on a future job application. You understand that?
Yes, I do.
As to the charge of open alcohol in public, ma'am, how do you plead? Guilty, not guilty, or are you standing mute?
I plead guilty.
Have a factual basis, please.
Thank you, Your Honor. Ms. Hunter, on October 12th of 2022, were you located near 500 near like South Pennsylvania, East Kalamazoo Street in the city of Lansing, Ingham County, state of Michigan?
Yes, I was.
Okay. And it was on South Pennsylvania, and were you observed in the middle of the roadway with an open Bud Light container?
Yes, I was.
And that was you were observed by the Lansing Police Department, correct?
Yes.
All right. And at that time, you knew that you had an open container of alcohol in your possession?
Yes.
Your Honor, I have no further questions.
Any questions from the city?
Nothing from the city, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. Sally, are you aware if she has any time served on this?
She does report that she did maybe 3 or 5 days, Your Honor. I'm not exactly sure.
Yeah, I do see there's been at least one bench warrant on this matter. Maybe 2, I'm not sure. Okay, I'll credit time served and close the file. You're all set, ma'am, and good luck to you at Bear River.
Thank you so much, and you have a great day.
Same to you. Okay, did you need to speak with Rebecca Radicio?
Yes, Your Honor.
Okay, we'll have you placed in a private meeting room. Miss Buff did not return to the courtroom. Do we know if she left the building? Mr. Chisholm, did you and Ms. Buff create a joint pretrial statement?
Your Honor, we did not, but we did get this worked out, Judge.
Okay, so you did come to a resolution?
We did, Your
We are
Honor.
back on the record in the matter of Orbit Leasing versus Andrea Buff, file number 22-00392 GCE. The parties met privately. Mr. Chisholm says that you all came to an agreement.
Yes, Your Honor.
Okay, can you put that on the record, please, Mr. Chisholm?
Judge, what we've decided to do in this matter is Ms. Buff agreed that she does owe the money. What we've decided to do, Judge, is a couple things. Number one is I have agreed that there will be no interest assessed on this account at all going forward. So no matter what, there won't be any interest. The second thing is that it will be paid in the amount of $100 per month beginning January 20th of 2023. And the third thing is I've indicated to her and actually given her the direct number of the director of legal recovery. They're my boss, essentially, who is the one who makes the decisions on the cash settlement offers. I have given her the experience that I have with respect to what a normal settlement is, given the situation, and kind of given her some advice as to how to go about doing that. Ms. Buff and I had a long conversation. I think we've got a good plan in place here, Judge, to get this taken care of.
Okay, so it sounds like you're still working through the settlement amount? Is
No,
that-
Judge, no, I'm just saying with respect to I think that with the what we've come up with here today, I think works for both parties, Judge, is what I'm just interjecting that.
Okay, sounds good. So no interest is gonna accrue, but payments will begin January 20th, 2023 in the amount of $100 per month. That's the understanding. What is the total amount that she's paying?
That is $66.81 Judge. I did confirm the fact, Ms. Buff, there was money withheld from her, but her employer has given that money back. And so she was made whole, and Orbit Leasing did not receive any money.
Very good, and that's accurate to your understanding as to the agreement, ma'am. You're gonna pay $6,681.73 and the amount of $100 payments per month. No interest is to accrue during those payments. Okay, and so Mr. Chisholm, you'll get that in writing and filed with the court, correct?
I will, Judge, yes. Would you, Judge, should I submit that under 7-day rule, or you want me to email that to your clerk?
Yes, if you could submit that under the 7-day rule, that would be great.
Will do. Thank you,
Let's
Judge.
see. Do you have any questions today, ma'am?
No, ma'am.
Okay, any additional matters for the record, counsel?
No, Your Honor. Thank you. Appreciate your time today,
Thank
Judge.
you. No problem.
And
You're all
appreciate
set
Miss
today.
and
Thank
we
you.
appreciate Miss Buff working with me as well.
Thank you.
No problem. Okay.
Thank you, Your Honor.
Thank you. Have a good one.
You too.
Let's stick around.
Okay.
Where's that girl?
This fellow on that matter, waiting for her to return. And then I do see Brandy Day and Mr. Haynes have returned. Okay, on the record in the matter of MPC Cashway Lumber versus Brandy Day and Titanium Builders LLC. Parties did complete their creditors exam, is that correct?
We have, Your Honor, we'd like to put something on the record if we could, very quickly here. Ms. Day and I and her managers have a chance to discuss this matter. They have agreed that they are going to pay $500 a month commencing December 19th. And the same amount on the 19th of each month through February of 2023. And then starting on March 19th, it will be $1,000 a month through May. And then on June 19th, the balance will be owed. And if what we would like to do with your permission is reschedule this matter for December 19th at 2:00, if that works for you as a control date. I'm going to prepare a payment agreement that has additional terms that Ms. Day and I have discussed, and she's agreed to sign it and return it to me promptly. And we will let the court know if I get those, so you can take us off your docket on the 19th if that works for you.
A control date, the 19th of December.
Yes, ma'am. Just to make sure that first payment and the written agreement come back.
Yep, the 19th at 2 p.m.
Do you want me to send out a re-notice of that, Your Honor?
We'll send a notice.
Okay. I think that's all we have unless Ms. Day has something.
Nope, thank you.
Okay, very good. Then you're all set for today. Thank you.
Thank you.
Judge.
Thank you. I don't see Miss Till. Okay, Miss Donnelly, are you ready?
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the city of Lansing versus Rebecca Verdicia, file number 22-02452, council appearance.
On behalf of the city of Lansing, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Rebecca Riverdiccia, who is appearing separately by video.
Okay, today's the date and time set for a pre-trial. This matter was adjourned because I think the office of the attorney was trying to see if the victim was seeking restitution. How are we proceeding at this time?
Your Honor, to the best of my knowledge, we have not received any communications back from the victim. A crime victim rights letter was sent, but I do not have the record of any response in our file.
Donnelly?
Your Honor, we were hoping that there would be contact with the complaining witness in order there to be a possible offer. At this time, we would need time basically to consider the options. If there's not going to be an offer, then I would like to discuss with Ms. Verdicia the possibility of a trial or a plea.
Do you want another pre-trial date?
Yes, just a short adjournment, Your Honor, should be necessary. Are you comfortable with that, Mr. Verdicia? Did you time to consider the options, or would you like to decide today? No, okay, good. That's what I thought.
December 19th at 2 p.m. Any additional matters for the record?
Nothing for the city, Your Honor.
None for defense. Thank you, Your Honor.
Okay, you're all set. I'm assuming Ms. Still left.
She sent that via email.
Okay. Sounds good. Ms. McNeil? You're muted. Ms. Rudisha, you're all set for now. Thank you.
Okay, thank you. Have a good day.
I took you off mute.
Ms. McNeil, it looks like you did come to a pretrial statement with the plaintiff. Is that correct?
Yeah, she said we came up with a rough estimate just to kind of give us a
Okay,
brief.
sounds good. She filed it with the court. I'm going to review and sign it. It said that you gave permission for her to put your name on there. That's correct, ma'am?
Yes.
Okay, then I review and sign it. You'll get a notice of your next court dates in the mail, okay?
Okay, and me agreeing to sign it, that's just saying that, not saying I agree with the statements that they made, just saying that they went over it would be correct.
Correct. So this is the joint pretrial statement. This is what we use to kick out a scheduling order. So you didn't sign it. You're not signing anything saying that you agree to pay what they're asking. You all put what the case is about and how much time you need to do discovery and such, and then the court reviews it and sign it, okay?
Okay, and you said you'll send us in the mail our court date?
That's correct, ma'am.
Okay, thank you so much.
Thank you. You're all set.
Okay, thank you. Bye-bye.
No problem. Okay, we're on the record in the matter of the people of the city of Lansing versus Johnny Charles Miggins, file number 22-01820. I also have 22L2723591. Council appearance.
Matt Staples on behalf of the city of Lansing, Your Honor.
And good afternoon, Your Honor. Dustin Kuntz standing in today for Matt Nagel. Johnny Higgins.
Thank you. How are you doing today, sir? How are you?
Good.
Today was the date that was reset for a ruling. We were here back in October. I'm sorry. November for a evidentiary hearing, which turned into a motion to suppress, at which time the court took testimony and reviewed some body cam of an incident having occurred at the time of the stop. The argument from the defense was that the standardized filter varieties were insufficient to generate enough clues to support poor performance, particularly on the walk and turn, and that the administration of the SFSTs warranted the suppression of such evidence. I remember the officer's testimony. I don't dispute that there's a concern about the administration of the SFSTs. It was poorly done, and there's a reason why they're standardized. You can't just make things up as you go, or if you're not clear, you need to get better training. The question, though, that was before the court was whether or not there was enough to withstand the charge outside of that. The argument presented by the people of the city of Lansing essentially was that the SFTs are not required, and reasonable suspicion clearly existed prior to the performance of those SFTs, and that was based on the officer's observations and his indications about the condition or present impression of what the condition was of the defendant at the time of the stop. There was some admission, I think, to having consumed alcohol within the hours prior to that. Had those tests being administered. And so the court did opine, or is opining, I should say, that even without the SFSTs, there was sufficient enough, or there would be sufficient enough evidence to withstand the charges based on the officer's observations. And so because of that, the court is denying the defense motion to suppress. In this case, will continue to trial. Did we already have this set for trial? Okay, we did not. So then we'll set it for a pre-trial. I think what it was, is we had it set for evidentiary hearing and it turned into a motion to suppress. So the court is denying the defense motion at this time. This matter will continue, and the next court date will be a pre-trial and explanation hearing.
Does the court have an order? Usually I would just have a checkbox granted or denied when we do our motions.
I'm trying to see if one was filed. There is an order here. I will sign that and date it for today. And we'll get you court dates now for our next pre-trial.
It'll be January 3rd at 10 a.m.
January 3rd at 10 a.m. will be the date for the pre-trial and the explanation hearing.
Would it be in person?
It could be via Zoom. Yep, you do not have to appear in person for the pre-trial. You would only need to appear in person if we're gonna have a trial, okay? Any additional matters for the record today?
Nothing for the city, Your Honor.
No, thank you, Your Honor.
I should have given those exhibits back then, but maybe I don't need them. This was from the officer, actually. You might need this. Did we give him a copy? We gave him a copy. Okay, sounds good. We'll keep it in the file. We'll get you a copy of your notice to appear, and then you'll be all set. Okay, sir? Thank you. We're off the record. Okay, did I miss anybody? I don't think so.
Your Honor, have a good rest of your day.
Thank you.